Hello, everyone. This is Tom Fox back again for another episode of the award-winning All Things Investigations. Today, I'm joined by Hughes Hubbard and Reed partners Mike DeBernardis and Sean Reilly. Gentlemen, welcome to the pod.
Thanks, Tom.
I guess I'll start with you, Mike. Hughes Hubbard had an announcement about reorganization of some of the lawyers and skill sets to, I think, really map against what the administration's new priorities or enforcement are. So maybe if I could start with you to ask, tell us about the reorganization.
Yeah, what we've done is created a task force really focused on, we had seen some of the changes that the administration was making, its focus on fighting the cartels, and in particular on the announcement of designations of the cartels, particularly in Mexico, but a few in other places as well, as foreign terrorist organizations, and had given some thought to the implications of that change for companies and the idea that a lot of enforcement effort might be focused in that area, given the stated goals of the administration. It's a new area, so we don't have, no one has sort of a practice group around that, around this emerging area. And as we thought about it, we realized it's really not one skill set that's important here. I think it's really a cross-disciplinary solution that's necessary. And so what we did is I think we're fortunate enough here to be a pretty much full service firm and have some really great people in the areas that are most important. So we put together a team that includes leaders from our compliance and investigations practice, from our sanctions and export controls practice, and from our dispute resolutions practice, particularly those with experience in Mexico and Latin America, with the idea that we can really kind of cover all the bases and potential implications of this change and potential focus on these cartels in Mexico.
And John, I've also had the chance to visit with you previously on a podcast, and you opined a few times about what Secretary of Treasury Reilly might do in this situation. But before you move to that position, you may be responding to what the current Secretary of the Treasury is ordering in the way of either additional sanctions or putting parties on certain designated party lists. How does the changes the administration, or that might not even be fair, the re-emphasis of the current administration really play into the skill set of this new task force and how you can bring the skills that you guys and ladies have collectively to any client, whether it's a multinational energy company, a regulated industry, or somebody who's just focused their business on south of the border previously?
Sure, Tom. Yeah, I think the thing that's important for people to recognize is there were these 8 cartels that were designated in mid-February as foreign terrorist organizations and also as specially designated global terrorist organizations. And while 6 of those 8 had already been designated as SDN, so they were already on Treasury's radar, and obviously they were also already on law enforcement's radar. What these new designations did was they sort of significantly upped both the compliance obligations and the risks for companies that cross paths or individuals that cross paths with these organizations. And they also, on the Treasury side, they increased the tools available for Treasury to monitor and then cooperate with other government organizations, law enforcement, to enforce against these cartels. And as Mike said, it's clear that the government, across the government, is focused very heavily on the criminal enterprises south of the border. They're focused on it from an immigration perspective. They're focused on it from a trade perspective. The tariffs that have been put in place, specifically against Canada, Mexico, and China, are focused on fentanyl trafficking. There's been discussions of human trafficking. And then the Department of Justice has sort of reorganized in significant ways its efforts focused on the cartels, going as far as to sort of focus the FCPA enforcement group on FCPA as it relates to the cartels and activity in Mexico. So there's a lot that's going on, and that's why, as Mike said, we sort of got our heads together and said all the different skill sets that we have within the firm, how do we make sure that we're working together to best serve clients there so that they're able to respond to what's increasing both the risks for companies and also, again, increasing the government's ability to look into the cartels and perhaps have more information that, again, heightens the risk for companies that may be operating and dealing with agents or affiliates of the cartels without even knowing it. And so making sure that we're talking with our clients about what do they need to do to stay one step ahead of that.
Sean, let me pick up on one word you used several times in there. That word was risk. And when a compliance professional thinks about risk, they think about risk identification, risk assessment, risk management strategy, training employees to implement the strategy, then monitoring the strategy after it's implemented and improve as appropriate. And one of the things I'm trying to communicate in multiple podcasts that I think you just said was, now's the time to reassess your risk and see if there's a risk there. Before you get that call or before you may have to make a call, are you getting calls from clients or you're able to counsel clients that you can actually be proactive in this area and step in and look at these areas that for some companies you may not have been on your radar, as you said?
Absolutely. That's exactly what we're trying to do with our clients is, as I mentioned, again, specific to these cartels and newly designated terrorist organizations, they were already on the SDN list. So there was already a lot of our clients already had processes in place to screen against the SDN list and to do a due diligence that's tailored to that, and having them understand that now the risk profile has changed because on this new designation, there's additional risks that go along with it, both civil, criminal, and also civil liability in terms of being subject to private action against companies that are found to have provided material support for these organizations. And so reevaluating the risks, making sure that the compliance program that might have been sufficient 2 months ago, make sure that that is being recalibrated for the new risks. And then, as you said, pushing it down to employees to make sure that they understand that what they were doing 2 months ago that might have seemed like just normal, what you needed to do business, that this may actually raise additional red flags. So maybe there was a guy that was forcing your Mexican operation or suggesting strongly to someone in your Mexican organization that you should use this trucking company because you can be sure that your product is going to get to its destination. Now you need to be thinking about, why are they telling me that? Am I really dealing with the cartel? Am I making a protection payment essentially when I use a endorsed vendor down in Mexico, and making sure that you're aware what the potential implications of that are and that your employees or your agents down in Mexico are aware of that and not running afoul of these rules.
Mike, if I could turn to you, in late April, there was an enforcement action with the National Security Division of the Department of Justice, and it was for the illegal shipping of certain software by a company called USRA to a designated party, Beijing University in China. And there was a couple of really interesting things about it. First was a full declination was given. The second thing was that the declination process, while similar to the FCPA declination process, was actually issued by the National Security Division during the Biden administration. So we're going to have a continuity there. But it was also a very powerful statement that this administration will give benefits if you self-disclose, if you fully remediate, if you fully cooperate, you turn over information on actions of illegal parties, and then remediate any profit. Pay back any monies that you illegally got. There you go. Disgorge. And so I really wanted to use that as an introduction to you, and that's a skill set you've used many times in other areas. But if we have that strong a statement from the administration, can you now really have that really difficult conversation with a client? This is a high priority of the administration. I might not have suggested self-disclosure before, but with a clear benefit of this case that you could show them that it really might be in their interest to seriously consider self-disclosure, and then you could help them through that process as well.
Yeah, it's a really great question, because I think up until late April on this case, there was I was having a lot of conversations with clients and with other lawyers about, is the voluntary disclosure conversation dead? Are we just not going to have that, at least for the next few years? Are we instead in a place where the Trump administration is just not focused on corporate enforcement and it's not worth the effort? This is clearly a signal that, at least for particular circumstances and in particular areas, it's very much not dead. That response that we've now been discussing in the FCPA and other contexts for a few years of quick, rapid investigations, thorough investigations, really good cooperation, self-disclosure, remedial steps, that can lead to a very, I would say positive, but a best case scenario to resolve these matters. This is a signal that conversation is not dead. So I don't know yet. I think I'd probably personally need a little bit more. I need a little more evidence that the Department of Justice under current leadership is truly as committed to encouraging voluntary disclosure and offering that carrot over and over again before I'm advising clients to take that approach. But this is a big step, and especially when it comes to national security related issues. I think you really are going to want to have conversations about that approach when it comes to national security issues, and especially about making sure, because the first step in getting that credit and voluntary disclosure credit is doing an immediate and thorough investigation and making sure clients understand, especially in the areas that might touch on national security, whether it's export controls, or I also think these FTO designations, that responding quickly with an investigation is critically important, because then you have the option. Right? Now you have the option of, let's make a really hard decision about disclosing or not disclosing.
I'd also like to ask you guys a little bit about the task force in terms of its cross-functional skill set and approach, because it strikes me that there may be multiple different laws that companies need to look at, particularly private sector companies who may not have considered those before, and what the task force allows Hughes Hubbard to bring to its clients to look at areas that they may not have focused on before, or conversely, if it's you're simply focusing on FTO and you actually stumble upon an FCPA violation, even with the suspension, does it give you the ability to provide really a holistic package of not just support, but counseling too?
I'll go first. I think absolutely. And that's sort of the design. At Hughes Hubbard here, especially in our Washington office, it's not a huge office. So all of us are talking about issues pretty regularly on an informal setting. The goal of the task force, I think, was to make that a little more formal, to sort of make our conversations a little more deliberate, so that we can be having holistic conversations, especially about particular clients where everybody is still trying to figure out what's important to this administration in terms of enforcement. Some of the skills that were developed in the FCPA compliance space over the last 15 years in terms of really doing diligence on your third parties, customers, vendors, how important that is and how to do it, we recognize are equally as important when we're talking about assessing our risks in the FTO space, especially in Mexico, and looking at supply chains, et cetera. There's other risks, and I'll let Sean talk about them a little bit more, but other risks in terms of private right of action now under these designations that companies need to be thinking about. That's why we have on the task force some of our dispute resolution folks, especially those with experience in Latin America and Mexico, to help if that comes up. And we just want to be able to be dynamic in the way we are responding to client needs, and frankly, dynamic in the way we are responding to the signals that are coming out of the administration as to what they're going to focus on and what's important to them.
Yeah, I would just add to that. There's obviously this obvious intersection between the anti-corruption, white collar sanctions, export controls, and part of the reason why that's a big part of the team. But as Mike mentioned, the new thing that also is generated by these designations is the potential of private action, and individuals, victims of violence by the cartels, specifically, but any victim of the cartels would have the ability under the Anti-Terrorism Act laws in the United States to bring a private suit against anyone who is seen as aiding and abetting those terrorist organizations. So there have been cases where companies that were doing business in one case, some of the example cases, in one case, a company doing business in Colombia, another one doing business in Syria. They ran afoul of providing material support to terrorist organizations in the form of making protection payments. It was the only way they felt they could do business and continue to do business in that area was to pay off the terrorist organization by making protection payments to keep their employees safe. And in addition to then having to settle that liability, civil liability with the U.S. government, they have now been sued. In one case, there was a judgment in Miami for several $1,000,000 against the company operating in Colombia. There's actions currently pending in New York against the company that was involved in Syria, where the victims of those terrorist organizations are filing suits. So having our dispute resolution and litigation teams that can also step in and help with that litigation is also kind of a service that we can provide if in the unfortunate event that something like that happened. Certainly when you have sort of the cross-border operations of these cartels where we know there's violence happening in the United States that is being attributed to MS-13 or Tren de Aragua, the possibility that plaintiffs' firms are looking for plaintiffs in the United States who would be able to bring actions against companies or individuals that were doing business in some way with these cartels or with their agents. That's a significant new liability that a lot of companies aren't aware of.
We've talked about risk in the context of the federal government either maybe cutting back potential risk under the FCPA or expanding it in other areas. But let me talk about risk in another direction, which is the expansion of risk. And you guys already hit on it in terms of private actions. But I was at a compliance conference last week where several panelists talked about false claims acts, claims on tariffs and tariff evasion. And that's a risk we never considered before. How do you counsel a client that whether it's called China washing, whether it's where are you buying your goods, should you be looking? How do you begin to counsel a client on the risk of a tariff violation and equally that someone could file an FCA claim and look at significant dollar return if successful?
Well, I'm going to let Sean cook here because I know he's been thinking about this a lot. And I know that because I think the last 4 or 5 conversations we've had, somehow our conversation has ended up talking about this specific issue. So I'll cede the floor to Sean here.
Yeah, Tom, we may be in need of another task force. But that's certainly something we're thinking about a lot and we're counseling clients on is, right? The first instance when these new tariffs were put in place, there was just a lot of focus on what are the numbers, how is this all going to work, and kind of the mechanics of dealing with the tariffs. But we've already seen and heard, and this is no surprise, that there's already talk. There have been press reports recently, I think something yesterday in the Financial Times, about countries that have high tariffs placed on them. Manufacturers in those countries are talking about looking at ways in which they can reroute their goods through other destinations, have them repackaged, relabeled, with the idea that they'd be able to come in under a lower duty. And in addition to the tariff rules and the civil and criminal liability that's associated with that, that also opens up under the False Claims Act. You can be sued for essentially filing the false paperwork that avoids the duty is a False Claims Act violation. And so there have been cases already where companies have faced liability either for not properly identifying the country of origin because that was going to help avoid a duty, or misclassifying in order to get a lower duty. So we know those are coming. We know these tariffs are unquestionably a high priority of the administration. And we're counseling clients, again, that may have had what was an appropriate trade compliance program in an environment of relatively low tariffs, lots of products that don't have any tariffs imposed on them. Now that everything has at least a 10, or virtually everything has at least a 10% tariff, and now there's a variety of other programs that are going to be putting other tariffs in place, there are going to be bad actors who are going to be looking at ways to avoid this, right? Everybody is going to be looking at ways to minimize their tariff liability. And there's lots of ways that can be done legitimately and ways in resourcing. The tariffs, one of the reasons for the tariffs is to try to change trade flows into certain countries and all that. That's some of that is normal and natural, but making sure that companies are doing it in a way that they're documenting it, it's transparent, it's defensible, and that they're not falling victim to somebody who thinks they've got a bright idea to avoid tariffs. That is the difference between minimizing your tariff liability and evading tariff liability. And that's where the real danger lies for companies that end up either facing civil penalties where they're paying several times the duty that would have been owed, or a False Claims Act violation that involves penalties and also increased damages in addition to that.
Yeah, we have, to me, this is inevitable. This scenario is inevitable, Tom. And if I agree with Sean, it seems to be a main focus, primary focus, however you want to frame it, of the administration is on tariffs. And you would think if they're going to put efforts anywhere to enforce anything, this would be it. And as we've spent, I don't know how many hours on the Corruption Files podcast and others talking through past corruption cases and identifying the fact that people do risky or bad things in business when they are desperate, or where they view an opportunity for triage for some sort of quick win. And I think both of those scenarios are potentially in play here, where if you are in China with a whole bunch of product that is now 100 times more expensive or 100% more expensive because of these tariffs, and you can find a way that you might be desperate to find a solution. Or if you are one of these middlemen and you're seeing that there's all these potential suppliers who have this product, they'd like to get it to the US and not have to pay these massive tariffs, there's an opportunity there to come up with some creative / illegal ways of making it happen. So it's a recipe for violations here, and it's simply a matter of time in my mind.
Yeah, and Tom, I just add, because under the False Claims Act, where you really are going to have problems, right, is you're now subject to a key TAM action, treble damages, and so now you've just deputized every disgruntled employee, every competitor of your that thinks that now I'm getting screwed because I know that guy is avoiding tariffs by going through another country and misclassifying the information. All the risk profile associated with that is enormous, because there's lots of people who now have an incentive to find it out and to root it out and go after it.
If we added rationalization to the pressure and opportunity, we've got the fraud triangle.
There you go.
So
I'm sure we could come up with a rationalization. I'm sure
we could. So are you suggesting that if you go back to when DeepSeek came out with their new Gen AI, and it turned out that they had bought all of their NVIDIA chips through Singapore, and Singapore had bought more chips than the number of people in Singapore, if Singapore's exports to the U.S. go up 100-fold or some other large number that's more than the aggregate population, perhaps you need to take a closer look at that?
Absolutely. Yeah, no, that would be one of the first red flags. If suddenly your sourcing people tell you, hey, we've just got this new source in Malaysia and it's only subject to the 10% tariff, not the 145% from China, you should be asking questions. Really? When did they when did they build the factory? Where did they come from? That's just the first step. But yeah, those are the sorts of things people should be on the lookout for. If it's too good to be true, it usually is.
I usually end podcasts by asking, I hope we can continue this conversation, but I think I'm just going to admit that I know we're going to continue this conversation.
Absolutely.
Yeah, I'm looking forward to it.
Gentlemen, thank you again.
Thanks, Tom.
Thanks, Tom.